you also have your app too.
Yeah.
Yeah, I know. I was just thinking the same
What app?
thing.
You got an Apple?
Oh.
Apple?
No, I don't have an iPhone.
Okay. I'm working on the other one.
Oh, you have to have an iPhone.
So, general provisions. Unless otherwise indicated, all proceedings under this article and all proceedings within the jurisdiction of the court under 202. So just talking about the jurisdiction.
Okay.
All right. Now, A, may be commenced by a fiduciary, a creditor, or person interested. So we know the fiduciary, those the voluntary administrators, the regular admin, DBNs, CTAs, executors, trustees, all of that. Creditors, so that's like the mortgagees or maybe the funeral creditor or whatever the creditor might be, or persons interested. B, may be entertained by the court or may be reserved for determination in an accounting or other proceeding, or the court may decline to entertain the proceeding. All proceedings shall be deemed entertained unless rejected by the court in writing within 15 days of submission.
So, I got a question for you. I thought that piece, the 15 days, was only for miscellaneous, and somebody, I don't know where, whatever, they said, no, that's for every petition that's filed.
No.
So we know that for a fact that under this article, based on statute, it's for miscellaneous. But like for this particular statute, it's miscellaneous.
I never knew that.
And some courts, like I worked in miscellaneous in Queens too, and some courts immediately it doesn't go to cashier first. They either say entertained or not entertained, and then it goes through. Like they choose however they want to do it first.
You leave the check from the payment, and then
We'll figure out what they want to do, the judge, and then it'll get
So it
processed.
has to be reviewed, and either they ain't gonna accept it or not.
Right.
Okay.
And then there are some proceedings, but we'll probably get to later, that must be entertained by the court.
Okay.
C, I guess we could highlight that 15-day. I don't know if it's going to be on a test. I haven't seen it, but they can always do that. C, shall. So shall or must be commenced by petition or any other pleading directed by the court stating the jurisdictional facts and the facts applicable to the particular relief sought. So that's also any petition, they have to make sure they're in the right venue. But I guess for miscellaneous, they have to exactly state that. And also the relief, which is the wherefore, and that's in all petitions as well. Or any other pleading directed by the shall be commenced by petition or any other pleading. Okay, so some miscellaneous proceedings is by application as well. Number 2, the jurisdiction of the court over the proceeding shall be deemed to continue until a decree or order therein is fully satisfied. So, that keeps going until the judge gives an order or decree. And then we also know things could get withdrawn or whatever. Okay. 3, if the petition or other pleading is entertained, service of process shall be made upon all persons interested in the proceeding and upon such other persons as directed by the court, except that in any proceeding against fiduciary under 2102, service shall be made upon only the fiduciary unless the court otherwise directs. So y'all understand that? So we were just talking about it earlier, Kathy. The relief against fiduciary is usually you telling the fiduciary to do something like, hey, you owe me money. I want you to give me the money. Or, hey, you're blocking something from happening. Let's go to court and see what's going on. So that's a relief against fiduciary. And you don't have to serve everybody else. You just need to serve that person. In any such proceeding, the court may grant appropriate relief, grant or deny the relief in whole or in part upon such terms as it deems proper, and make such decree or order as justice shall require or may require a refunding bond. I'm not sure about the refunding bond. Refunding the term that, but I know that the judge can say a bond is dispensed with or not,
You're talking about
or
number
carry
4?
over.
Number
But-
4?
Yeah, number 4.
Yeah.
But sometimes, okay, so does that mean, so let's say like they got letters and they had to post a bond.
Mm-hmm.
So then when they come to, whenever they do another proceeding, that the bond is still an interested person.
The bond company
Yeah.
will be interested,
Yes,
but we can decide, or the judge decides whether or not they're going to add on to it or just do away
Yeah,
with the bond.
but don't they have to know if they if the bond has been discharged? Yeah, that's why I always thought that
The
they
bond
needed
get discharged through us also, through the
Okay.
miscellaneous department.
Okay, all right, okay.
Mm-hmm.
So when the decree is initially done and assets have not been distributed because.
You mean like in administration or probate?
Yeah, yeah. So the bond is set at that point.
Mm-hmm.
And then depending upon what the proceeding is in miscellaneous, if they've been a bad fiduciary, the
yeah.
judge might turn around and just say, you know what, I said 20,000, I think I'm gonna up it to 50, based upon the facts in this case.
But also if there's more assets.
No, that's only if there's
Oh,
one.
there's
Yeah,
more.
yeah,
Only if
Mhm.
there's more assets?
yeah.
Mm-hmm.
Once
Because
the
it has
bond
to
been-
cover something.
Yeah,
Right.
yeah. The bond is because they didn't they like if they had to cite somebody, no, they didn't get waivers from everybody. And then, that's why they set a bond.
Mm-hmm. To cover that person's
To cover that
interest.
person's
Person's
share. To
interest.
cover that person's
Mhm.
share. Because I know one of my friends have a case now. So he just came back to lift the restrictions so he could sell the property. And there was a bond.
Prior to.
There was a bond prior to that. And he definitely has to, because I'm
Serve
trying
the
to help
bond.
him. Yeah.
Mhm.
He has to serve them. They either have to waive, but right now the bond
Yeah,
is still
and
ongoing.
sometimes they waive it. Sometimes
Yeah, I
the
know,
bond
but
company
he
waive.
owes money to the bond company.
Oop,
Yeah, he owes
okay.
money. Yeah. So that's why I was saying may require a refunding bond.
May. That's why the key word is May.
May.
Yeah,
So
yeah,
possibly.
yes,
Right.
Yeah, possibly. Yeah, you're right. May or must.
Mhm. Shall is must.
Shall,
May
shall,
is
yeah, yeah.
maybe. Yeah. 2102. Cool. We went right into it. Relief against fiduciary. A proceeding may be commenced to require a fiduciary. Number 1. 2. Supply information concerning the assets or affairs of an estate relevant to the interests of the petitioner when the fiduciary has failed after request made upon him in writing thereof. So the person who's bringing in the proceeding, they have to say that they already reached out to this person and they're ignoring them, or they haven't been able to reach them, or something like that, if it's concerning this. Number 1, the information. Number 2, to set apart and turn over exempt property to which a spouse or child is entitled, or if it has been lost, injured, or disposed of, to pay the value thereof or the amount of injury thereto. And I'll just think of like real property. Let's say the fiduciary is holding on to it, or sometimes they put in their own name. A proceeding's brung, they have to either turn over that property. Hopefully they didn't sell it. If they sell it, then now they have to give the money to the people that's interested in that property. Number 3, the after reservation for the payment of expenses of administration to pay the reasonable funeral expenses of a decedent if there are funds available for such payment. So like when things come to our department, we have to make sure that the funeral creditor is listed, or that's either in the affidavit to dispense with the bond, or if it's like a wrongful death compromise, we have to know who the funeral creditor is, because they have the right to ask for their money back if there's funds available. To pay a claim which has been allowed to deliver a specific bequest or property to a person entitled thereof, or to pay a legacy, distributive share, interest in a trust, or a claim for administration expense. And when a trustee is unable to deliver personal property to the person entitled, to pay the value thereof. That's similar. So if they owe something that's for someone through a will or pay legacy through like administration, you bring the proceeding. 5, to pay in advance to any beneficiary of an estate all or part of any beneficial interest to which he is entitled when the property of the estate applicable to the payment of debts, legacies, and expenses exceeds by at least 1/3 of the amount of all known claims. Legacies having priority and beneficial interests of the same class, and the beneficiary needs such payment for his support or education or of his family. So I guess they have to make sure if they do turn over that, or if they bring the proceeding, that the claims that's possibly known can still be paid if they submit for like whatever they want in advance. In advance really to the accounting. 6, to comply with such directions as the court may make whenever 2 or more fiduciaries disagree with respect to any issue affecting the estate. So co-fiduciaries can bring it against each other. 2103, proceedings by fiduciary to discover property withheld or obtain information. I think this might be something on here. Let me see. A fiduciary may present to the court which has jurisdiction over the estate a petition showing on knowledge or information and belief of any property as defined in 103 or the proceeds property. Anything that may be subject of ownership.
Any property, real property and personal.
So number 44 in definitions, property. Anything that may be subject of ownership and is real or personal property.
Mm-hmm.
So any property. And where we at? Or the proceeds or the value thereof, which should be paid or delivered to him, is A, in the possession or control of a person who withholds it from him, whether possession or control was obtained prior to creation of the estate or subsequent thereto. Or now that this person is the fiduciary, whether or not he was the fiduciary before, they still is entitled to turn it over to the person now that he's fiduciary. Mm-hmm. Or like after he becomes fiduciary, he still is entitled to take over whatever that is. B, within the knowledge or information of a person who refuses to impart knowledge or information he may have concerning it, or to disclose any other fact which will aid the petitioner in making discovery of the property. So information. C, he has reason to believe in the possession or control of a person described in subparagraph A of this subdivision, or within the knowledge or information of a person described in subparagraph B, so property or information, and praying that the inquiry be had respecting it, and the respondent be ordered to attend. So that's something.
Right, so order to attend. So that's
Order to attend.
That's a miscellaneous. That's language only in miscellaneous that you guys produce orders to attend, right?
We definitely do order to attend. I don't know if any other department does it.
Yeah, no.
But we do it.
So,
It's just like to be examined. It's basically like, hey, come up to court for this. It's like an order to show cause, but it's no stay needed. Yeah.
It's directing them to
come and speak on your behalf.
Right.
Yeah.
And that's only shown in the miscellaneous proceedings?
As far as I know.
Would a test question be that basic?
Actually, the compel will falls under probate, but it's a miscellaneous proceeding. Yeah. So that too.
And that's also
Order to attend. Mm-hmm.
The compel is what the the relief is given in the order to attend. For the compel.
I'm not sure exactly what gives it, but in that specific proceeding, there's an order to attend.
In the compel?
Compel will.
Okay.
Compel will.
Okay.
And be examined accordingly, and to deliver the property if in his control. So like with the compel will, if you have it, just bring it. Mm-hmm. And usually they come and they go to probate and file it. Mm-hmm. The petition may be accompanied by an affidavit or a written evidence to support, or other written evidence to support it. So, like, it may be, they don't have to, even though, like, many times we say, hey, we need an affidavit or affirmation in support. So they don't have to. They could put all the facts in the petition. 2, property as used in this section shall include any and all personal or real property, I guess just like in 103, in which the decedent had any interest, including chooses an action. What's that?
Is that supposed to be choices?
Chooses.
Chooses?
Choice is an I. Choosing an action.
No, I know, it doesn't.
I'm just going to highlight it for myself to, like, y'all, look at that. Money deposited in all property rights of the depositor consequent on the deposit of money by a decedent, grantor, or fiduciary, or for his account with any authorized banking authorization in respect of which the depository claims no beneficial interest other than its proper cost, fees, or expenses. 3, if the court be satisfied there are reasonable grounds for the examination, it must make an order, make an order accordingly. If the petition does not pray for an inquiry or examination, the court may issue a citation to the person alleged to be in possession or control of the property to show cause why he should not deliver such property or its proceeds or value. So they can get a citation, which sometimes we also do, especially if they want to turn over. Like, usually if they want property given, we usually issue a citation. And that's just here in the court, in this court. 4, if it appear at any time that a person other than the respondent claims any interest in the property or the proceeds or value thereof, the court may issue a citation to such person to show cause why he should not deliver the property if in his control or the proceeds or value thereof, and why the court should not determine ownership or right of possession of such property. So somebody else's name is on the deed type of thing, and maybe one of the kids sold it to somebody. Who knows? The kids of the deceased, and it wasn't his to sell.
Will the person that he sold it to also be compelled to?
That's what they're saying here.
Yeah.
So the court may issue the citation to that person. Service of any order for attendance and examination of any person must be made by delivery of a certified copy thereof to the person or persons therein named, and the payment or tender of each of the sum required to pay to a witness as a subpoena fee. Certified copy. Then he serves it on the party, whoever that is. The sum required to be paid to a witness as a subpoena fee. So I guess if they decide to call witnesses up, they could pay the witness.
So how much? What's the subpoena?
Yes, $30. Yeah.
Thank you.
Yeah.
Where is it?
14?
14.
It's on 24-14.
8.
The next page,
Oh,
the back.
14A.
Is subpoena
yes.
Ducey's?
$30.
Yeah.
Is that
It's
the
Ticum,
formal
right,
word
okay.
for subpoena?
Right, Deuces Ticum. Because they're subpoenaing
two of
for
them.
information.
I'll just put $30 there in
Right,
case that ever
okay.
comes back.
Right.
So you pay the $30 plus the cert, so it's $38 if it's a
For the
one-page order?
certification.
The certification is $6.
Oh, that's recording fee.
Recording is at $8.
Certification is 6.
But they saying you only pay the witness if there is a witness as a subpoena fee.
No, but you have to record it because whatever they come to file as the subpoena has to be signed by the judge. Because I worked in the Bronx. It was
But
a
there's no
county
real
miscellaneous.
subpoena here.
Huh?
There's no subpoena. They're not really filing a subpoena.
But that's what the Deuces Ticum is.
Oh yeah, that's a
That's
subpoena.
a subpoena.
But yeah, we send them to the cashier.
In the Bronx it's combined.
Okay.
Oh, like everybody. Yeah. Yeah, when they come in, we send them to the
Because I know
cashier.
that, and because I know in administration, when the creditors come to file their petitions, they have to bring an original death certificate, and if they can't get it, they
do the
do a
subpoena.
subpoena, but there's no fee
Right.
for it. Yeah, yeah.
Mm-hmm.
2104. Inquiry, trial by decree. Upon the return Upon the return of the order, whether or not the respondent answers, the petitioner may examine him with respect to the allegations of the petition. I'm gonna breeze through this one. I don't think anything is there. If it appears thereon that an issue of title of any property as defined in 103 or the proceeds or value thereof is raised, if he has not theretofore done so, the respondent shall be directed to serve and file an answer accordingly. But the examination, if directed by the court, shall continue. When an issue of title is raised, that issue shall be tried as a litigated issue. Any claim or title to or the right, any claim of title to or the right to the possession of any property of the decedent or the estate must be made by verifying answer. If the possession of the property be denied, proof of that issue may be presented by any party. The court may, in an appropriate case, make an interim decree, directing the delivery of the property not claimed by verified answer and continue the proceeding for determination of any litigated issue. If it appears that the petitioner is entitled to the possession of any property,
The decree shall direct delivery thereof to him, or if the property shall have been disposed of or diverted, the decree may direct the payment of the proceeds or the value of the property, or may impress a trust upon the proceeds or make any determination which the Supreme Court might decree in following trust property of funds. So that means that the property may be put into a testamentary trust? That's what miscellaneous proceedings?
we don't create testamentary trusts. That's something that happens through the will. We don't really create intervirus trust either. Like, that's already created, but maybe a trust upon the proceeds. Okay, may impress a trust upon the proceeds or make a, I don't think that means an actual trust, but just give me a second. I'll come back to that and I'll see exactly what that means. But I do know that the court can make a decision
It's for
on
the
what's to happen.
administration of those funds.
Yeah.
They're saying they may
Impress a
impress
trust.
a trust. I think that means, like, so if all this money is now being decided to come in, they want to put it in a place for safekeeping.
I don't want to give the wrong answer, but I can look that up.
Or may, so it says, okay, so let me see. It says shall have been disposed of or diverted.
So
The decree may direct
yeah,
the payment of
think about
proceeds
it.
of
Let's
the
say it's a
value of
piece
the
of property and it's an apartment building and they're collecting rents on it.
Mm-hmm.
So now they're saying
be
the
a trust.
petitioner should have that property, and the other people are collecting the rents. They now have to make sure that whatever.
Put it in
money's-
escrow or
put
something
it
like
in
that.
like an escrow. That's really what it should say. But you'll check on
And then
that?
we have Supreme Court, which has concurrent. Yeah, I'm gonna check on it. Concurrent jurisdiction.
Jurisdiction.
Let me
Wait, what?
Supreme Court.
Supreme.
Where does it say that?
That's if they put it in a
they-
trust or something. Supreme could
Oh,
Which
Well,
the
they-
make a
Supreme
decree
Court
on that.
might
I see.
decree in the following,
Mm-hmm.
in following trust property of funds.
If it is determined that the petitioner is not entitled to the property or the proceeds or value thereof, the court may determine the respective interests of the other claimants thereto. If, meaning it goes to whoever it's supposed to go to, it might go to.
Right. Whoever it belongs to.
Yeah.
Mm-hmm.
If during the proceeding, other than a trial of issues raised by answer, a respondent is examined concerning any personal communication or transaction between himself and the decedent, such examination shall not be deemed to be a waiver of the provisions of I don't have the CPLR up here. CPLR
4519. That's the dead man's law. I mean, the dead man's. I think that's what that one is.
No transactional communication between witness and decedent or person with mental illness.
That's
if anything is raised when the respondent has personal communication or transaction between himself and the decedent,
such examination shall
not be deemed to be a waiver
of.
So it still applies.
Allowing it when it's an inquiry.
They saying it shall not be deemed to be a waiver, so it's not going to waive the provision.
Okay. Mm-hmm.
So it keeps going.
So the dead man statute does
it applies. I think it applies.
It does.
I would think it applies because it's one person's word against
it's not waiving it.
Nobody.
2105. Proceeding to compel delivery of property by a fiduciary which is claimed by another or others.
Okay.
A person having a claim to a property we're not going to keep doing that. As defined in 103. Or the proceeds thereof alleged to be in possession of or under control of a fiduciary may present to the court which has jurisdiction over the estate as a petition showing the facts and praying the relief that the fiduciary be required to show cause why he should not be required to deliver the property or the proceeds thereof. Process shall issue accordingly to the fiduciary. So this is kind of like the relief against fiduciary. Kathy. Upon return of process, the court must hear the proofs of the parties, determine the issues, and if claim shall have been made to the property or the proceeds thereof by a person or persons other than the fiduciary, the court shall determine the respective interests of the parties in the property or the proceeds or value thereof and make a decree accordingly. By fiduciary. This is the turnover. This is the turnover.
Delivery of a property. That's the turnover. 2105, right?
Mm-hmm. So 2103 was the discovery. 2105 is the turnover. 2106. Proceedings for compromise of controversies between claimants to property or estates where interests of persons under disability or not in being are affected. Where the interests of a person under disability or not in being are or may be affected, a fiduciary may petition for authorization to compromise of controversy between different claimants to the estate property or portions thereof under administration in accordance with an agreement to which all parties in being claiming an interest in the estate affected by an agreement shall be parties in person or by guardian or committee. The proponent or any party to a probate proceeding may petition to adjust by compromise of controversy existing or which may arise between the persons claiming under any will alleged to have been made by the decedent or any persons claiming as distributees of decedent or claiming to be entitled to a right of election or claiming pursuant to an agreement with the decedent or otherwise in accordance with an agreement to which all persons as are interested shall be parties, provided that persons named as executors to whom letters have not been issued are not affected.
By the proposed compromise are not required to be made parties. Okay. So successors who may not have been.
are not affected, they're saying.
Mhm.
A person under disability or a person not in being who has a future contingent interest is a necessary party and shall be represented by GAL unless in the case of a person under disability, his guardian, committee, or conservator shall appear in his behalf. The guardian, committee, or conservator so appearing or the guardian ad litem may execute in behalf of the person for whom he appears all proper instruments necessary to effect any compromise approved by the court. Handful.
So
Go ahead.
the person not in being, that is talking about a person who is a child that is in utero, is woman is pregnant.
That will make sense to me. This is the first that I'm seeing it in this.
Because
You said it doesn't make sense to you?
No, that would make sense to me. Affected. I guess so. They're gonna have a GAL.
It's like so political because.
Well, that
he's
makes
not
sense
born.
though. That makes sense because that's still a child.
Mm-hmm.
I don't know if they're gonna try to do paternity, but it's still a child. And if they're married, they might not do the paternity. I don't know.
Well, I know when I was working in New York County, I had a case. I worked in guardianship, and the child came into money.
Mm-hmm.
And when we asked about the father, she said, the child had been conceived through a sperm bank.
Mm-hmm.
And she, so in California, it's legal. California is legal.
True.
So when she bought in, like the birth certificate, it, let me make sure I say this right.
And it's legal to what?
Well, it was legal, so that's how the baby was conceived. That's how the baby was conceived.
But that's legal anywhere. But regarding like the state, what is it?
But, because it was in California, so like on the birth certificate, I can't remember if I had a. I'm gonna write it down if I can get back, because when they come in to petition for the guardian of the property,
Mm-hmm.
we have that have to have a waiver from the other parent.
Okay.
So that was the reason why that issue came up, because
There was no father.
because there was no father. Yeah, and she had to show us how the child was conceived. Yeah, but in California, it's legal like that.
They
way
still don't need
way
the
they had
extra waiver.
We didn't need the waiver, but we just needed to know, why,
Why you
where
weren't
the
serving.
father wasn't dead.
But what does the
but
birth certificate say? What did the birth certificate?
See, I believe, I gotta look at my notes again. I believe that the way they had it worded on the birth certificate, and then she was able to bring us the papers of how it was done.
It's a not in being.
Mm-hmm.
Mm-hmm.
Contingent
Right.
interest, future, and a guardian ad litem is
That's it.
assigned.
Yeah. And we know a person under disability doesn't mean like
I'm
they're mentally
surprised
impaired.
at
They could be
that.
an infant.
I'm really surprised.
I'm sorry?
Why?
What?
Politically, I'm
What did you say?
That a person under disability doesn't mean like they're mentally or physically
No.
impaired.
No,
it's also
no,
infant.
No,
Yeah.
Right.
Okay.
And then-
Yeah.
So that's why it would make
Or
sense.
incarcerated?
Or incarcerated.
Yeah.
Yeah.
Mhm.